going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got two good ones tonight, guys. Well, first off, happy Tuesday. Hopefully you guys had a great day. You guys want to watch some court? I want to watch some court. Let's watch some court. All right, now what am I saying? Two good ones. We've got two sovereign citizens. One happened today, one happened yesterday. And yeah, first one's Judge Washington. Second one is in the state of Washington. It's a Thurston County judge. I don't know the Thurston County judges' names. Every time I play one, I always tell myself I got to learn the judges' names. I never do. But first one, Judge Washington. This is actually part 3, technically. Part 1 happened in front of Magistrate Braley about a month ago. Part 2 was about 2 weeks ago in front of Judge Washington. That's when she, went full sovcit. I put that one out there. I should have put the link of that one in the description, or maybe put them both together. I don't know. Anyways, this is part 2. That's what we're going to start with. But before I do hit the play button, we have a special announcement from a friend of the channel.
Have a blessed day and God bless America. Now during lunch, I can catch up on some YouTube. It's time for Cooling with Colin. Let's go.
The court will call the matter of the Ranches of Rosebrook versus Anise 1245.
Good afternoon, Your Honor. David Fantera on behalf of the plaintiff.
Ms. Battle, could you please state your name?
Battle.
I'm sorry, could you repeat that?
My name is Denise Battle.
Thank you so much.
Oh, Saint. Just wait. I imagine towards the end of this clip, there's gonna be about 25 people that leave. They're like, no, I wouldn't have.
So much, Ms. Battle. In this matter, this is an action to terminate the tenancy based on non-payment of rent.
Yes, Your Honor. I object to these proceedings moving forward because, like I said, I do have a verified petition in emergency motion for injunction in the U.S. District Court, which is the case number 25-CV-1.
No, now it's going weird because I'm stuttering. Something just happened when I hit the play button. My screen went black and came back. Hopefully that was just a one-time thing, and the rest of the stream will be okay. But yeah, I saw that too.
1, 2, 3, 3.
Thank you, Ms. Battle.
And like I said, this court has not put on the record their jurisdiction. There's nothing on the record, and it stands. Every notice that I've sent is unrebutted, which stands at law. And jurisdiction is a threshold issue that we shouldn't even made it this far without discussing proper jurisdiction.
All right. Anything else, Ms. Battle?
As of right now, no.
Okay, thank you.
But I object to these proceedings in jurisdiction, subject matter,
All right.
and personal.
All right, your objection is noted for the record. Ms. Battle, I've already ruled on jurisdiction when we were here last time. We will be proceeding today. The court does have jurisdiction. Mr. Fantera, and Ms. Battle, do either of you have?
I object. The court cannot declare its own jurisdiction
If
to
you
respond to it.
keep interrupting me, ma'am, you're going to get held in contempt of court, and the court does have contempt powers, so throw you in jail.
I interrupted you. Okay, that's all.
Your Honor, I want to point out also that Judge Vandenberg actually addressed this issue last Wednesday and said that the 14B District Court and Your Honor does have jurisdiction over this matter. So not that it needed to
May I add, Your Honor? Yeah. She also said that she was not aware of the things going on, so she just went on for anything based on what he just said. She had any law nor facts, just as you don't, of why you have jurisdiction. And it's no order that has it back yet, to be clear.
All right, thank you. Again, Ms. Battle, this court has jurisdiction and we will be proceeding today. Mr. Fantera, well, actually, the both of you have an opportunity at this time to do any opening argument that you want to make. So, Mr. Fantera, I will start with you. Do you have an opening statement?
I'll waive my opening statement, Your Honor, and just get right to the evidence.
All right. With respect to service, can you please put on the proofs regarding the service in case there's an appeal?
Say that again, Your Honor.
All right, before we get into the proofs, pay attention to the lady on the bottom. Hold on, what's her name? Dawn. She's the property manager. She cannot control her facial expressions, and sometimes they're hilarious. I captured one for the thumbnail, but they're funny. They're funny.
Can you please put on proofs regarding service in the event that there is an appeal?
Service of this lawsuit?
Yes, on Ms. Battle.
I believe that she was served by court officer with Jimmy Moore's office, Your Honor. I think there's a proof of service in the file. I don't know whether it was attached or whether it was personally served. But the court has that proof of service.
With respect to proof of service, the file indicates that Ms. Battle was served with two different ways pursuant to MCR 4.201D, which is she was served, actually three different ways. She was served with an original mailing from the court, and then a second mailing went out from the court. Second mailing was requested by the plaintiff and was sent by this court. On March 28th, there was a mailing. And then there was service by Edward Cope, who was the court officer. That service was effectuated through securing an attachment to the main entrance of the tenant's dwelling unit. And that was done on April 4th, 2025. And after attempts had been made on April 2nd at 12:40, and then April 3rd at 9:53, they finally did an attachment on April 4th at 4:30 p.m. In addition to that, Ms. Battle showed up to the court on April 9th, 2025 before the magistrate, therefore acknowledging that she had received service in this matter and that service had been perfected. Right. With respect to jurisdiction, we addressed that at the last court hearing. This is on Russell Court, which is within the jurisdiction of Ypsilanti Township. I think you hung up.
Oh, the lady with the kids is a sovereign citizen. And she'll be back in a second. But yeah, it does not get better with the kids. It doesn't. She starts yelling at him. Oh man. It's not good.
Your Honor, when she comes back, can we require her to, she appeared the last two times with a video. Can we require her to have video today?
Ms. Battle, are you back?
Yeah, we were disconnected.
Yes, Ms. Battle, you're back. All right.
Yeah.
What request were you making, Mr. Fantera?
I know the last two times that Ms. Battle has appeared, she appeared with a video, and this time she's just on her phone. Can we require her to be here by video today also?
I would have had to give
Well, the
her,
thing is like I tried to tell you all last time that the time was bad. This is when I pick up my kids.
All
So
right,
we
then
can
we
do
can
it
just,
like early.
Yeah, it's not up to you, lady. This is an eviction docket. They're on a timeline to get you out because you haven't paid rent at all this year. I repeat, at all this year. They're about to put the proofs on the record. You'll hear them.
Earlier or something of that nature, yeah, that's fine.
then I'm okay just proceeding as long as the court is comfortable that we can swear her in when she goes to testify.
thank you. I am comfortable. I can tell you that if I was going to require that she be here via video, I would need to give her notice of that prior to today's date. So I'm comfortable proceeding as we are.
Okay.
All right. And Ms. Battle, other than jurisdiction which has been noted and reserved, do you have any other argument you want to make today with respect to this opening argument?
Of course. So, like I said, the contract has been rescinded on April 1st, and it was due to unconscionable pieces in the contract, including pieces that's wrong with the formation, as well as material breaches that's inside the contract. That contract has not been
You said material
breaches.
Okay, go ahead.
Breaches, yes, within the contract as well. That was sent out and received. Well, it actually wasn't received on April 1st because at the end of the day, the unconscionable pieces, their addresses are wrong and the owners are wrong on the contract. So it got sent back. But once I realized it was sent and received on April 8th, 2015, and still remains unrebutted. They have yet to unrebut it in any case that we came and talked about the contract. And by law, according to Wall versus Zendaya, the Michigan law recognizes rescissions at common law for breach, fraud, and unconscionability. Meaning, if I give notice and it's unrebutted, that stands at law. Also, I've talked on personal matter jurisdiction, why I came in under special appearance the first two hearings, because at the end of the day, I'm not a legal person. I'm not in a legal capacity under Michigan law. I do not qualify as that person, which that person is a corporation, a trust, individual, in some type of legal entity of that nature, an association. I do not qualify as one of those people to be here and subjected to this without consent. Hence why, things were sent administratively and defaults were given administratively because things are happening right here where I'm being deprived of due process and I should be awarded due process by law. As the attorney stated last time we were here, he was saying that basically the burden of proof only applies in criminal cases, which is false because the burden of proof applies in all civil cases where jurisdiction or contract validity challenged, and that's Taylor versus Bullam in 1992 in Michigan. You still have the burden of proof. The court cannot establish their own jurisdiction being based on a contract is rescinded. You have to have a valid contract to come into court about. So that's where your jurisdiction of the subject matter is at hand because the contract is rescinded. Not unilaterally, like he's tried to claim before. It is rescinded, meaning I gave you notice and it's unrebutted, just as if somebody came into the courtroom for an eviction, or if they did not come for the eviction, you'll give them a default. Because what happens at law, your silence stands.
All right, thank you, Ms. Battle. Ms.
Judge Washington put herself on mute. She didn't want to be caught yawning or sighing. Oh, that's awesome. Oh, yeah. I stopped listening about halfway through that too, Judge. Don't worry.
Mr. Fantera, you may proceed with your case.
Plaintiff would like to call Dawn Charles as a witness.
All right. Ms. Charles, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing.
I do.
Thank you.
Yeah. it doesn't make any sense. So if you're not confused, then yeah, I don't know. Maybe you're a sovereign citizen. I don't know. But yeah. Jen, good to see you.
You may lower your hand. You may proceed.
Ms. Charles, please state your name for the record.
Dawn Charles.
And what is your position with the Ranches of Rosebrook?
I'm the property manager.
Are you familiar with the tenancy of Anise Battle?
I am.
Are you familiar with the lease agreement that she signed?
I am.
Your Honor, I submitted to the court a lease agreement dated November 12, 2024. I'd be moving for that to be admitted as Plaintiff's Exhibit 1.
Did you also provide a copy?
Biggin, thank you so much for the raid, my friend. I appreciate it. Welcome to all the raiders. We just got started with a sovereign citizen. This is actually supposed to be a formal hearing / trial to evict the tenant. When I'm not saying that it actually is this. I don't know why I started the sentence that way. We just got through opening statements. The attorney didn't have an opening statement. He just said, I'm just gonna lay on the evidence, and that's all I need. And the sovcit went on for about 5 minutes. Everyone was yawning. I think everyone stopped paying attention. That's what you missed so far. Biggin, thank you again for the raid, and welcome again to the Raiders. Oh, also, wait a second. My chat's not highlighting. All right, I gotta figure that out. I'll do that. Hold on. Let's just play.
To the defendant.
I did not, because I do not have her email address. But she should, Your Honor, I should say for the record, she should have a copy of the lease because it is, because she signed it.
Any objection?
I never received a hard copy of the lease, and I've asked for a hard copy of the lease. Never received it, and as I read the lease, that was also a breach of my lease, as I was supposed to receive it and sign it in person, as they made me sign it over online. So again, the information that he's saying about the lease is correct. I'm not here to argue about the lease as far as what the original contract was. I'm arguing about the validity of what it is now, which is invalid and void because it's been rescinded.
Thank you.
And unrebutted.
All right, given that she's not arguing about the validity of the lease itself, I will allow the exhibit
No,
one.
I've said I did argue about the validity of the lease as far as it being valid, because it's not. But I'm not arguing that I entered into a lease on or around December 6th. That's not what I'm arguing. I'm arguing the validity of the lease. So let's correct that.
You're arguing, you're not arguing that you entered into the, what are you arguing?
Like I said, I do not object to actually entering into a lease. What I thought was, yes, a proper lease on or around December 6th. I do not deny that, but I do deny the validity of the lease because the lease has been rescinded and it's unconscionable. Yes.
Yeah, the kids are the sovereign citizens. She said it earlier that they're there because this time doesn't work for her. During the last court appearance, she said this time was not good for her. She has to pick up her kids. And yeah, they're rambunctious. And like I said, it gets worse. Right now, it's annoying. It's about to get extremely frustrated, and it starts to anger everyone in the courtroom. Real quick, while I am paused, Clip Clap. Thank you so much for the 15 months. I appreciate it. Wow, 15 months. That is awesome. Thank you, Clip Clap.
Thank you. Her argument, as the objection in the case is that the lease is rescinded and therefore it's not allowed to be admitted. That is overruled and it will be admitted.
Oh, 1 second. Oh, y'all gotta. Everybody be quiet. I'm sorry, I didn't hear you, Judge.
I said that your argument that the lease is rescinded is not being admitted. The lease is admitted. That objection is overruled.
On what facts of law?
The fact that I just ruled that, ma'am.
That's not a fact or a law, so let the record show
You're
that
not
she has
going-
no
The
proof,
record
no
shows
law or no merit to
everything. The
object.
record shows everything,
I got
ma'am.
you.
You don't need to say that. And please
I know,
stop.
it will when I pull the transcripts, because like I said, this case is also.
All right, Mr. Fantero, you may proceed.
Okay, I want the record to show that I find it unfair that
Mr.
you can cut me off and
Ma'am,
use my mic whenever you
this
feel
is your
like it,
second
but I
time.
can't
You're
talk
being
and have a
held in
fair
contempt
hearing.
of court. You're going to be held in contempt of court and you're going to do jail time.
Wow, that actually worked. Generally, those threats don't work on, especially sovereign citizens. Mostly people with attitude. Doesn't usually work on them. What I was gonna. Sparkle Poats, thank you so much for the super chat. I appreciate it. Where does the last name Bay originate? I don't know the answer to that. I don't know. I know it's a Moorish sovereign citizen thing, so I don't know if that's I'm gonna have to say, just guessing, it has something to do with Morocco. I don't know though. No idea. Someone in the chat's gonna Google it and place it though, if they haven't already. I'm a little behind.
Mr. Fantero, please proceed.
Ms. Charles, can you, under the terms of the lease, what is Ms. Battle's monthly rent?
$10.75.
$1,075?
Correct.
Does she also have to pay utilities?
Water and sewer.
So for what months has she not paid her rent?
March, April, and now May.
So she owes $1,075 for each of those 3 months.
Correct.
Has she, does she owe the water and sewer for those 3 months also?
Yes.
How much does she owe for those months?
Her water and sewer.
Yes.
So March is $36.24.
April?
$35.45.
May?
$35.73.
Okay. That totals $107.42, correct?
Correct.
Are there late fees under her lease?
There are.
What is the late fee?
$50.
On what day?
The 6th.
And so she's being charged a late fee for March and April, correct?
Correct.
So the total she owes is $3,225 in rent, $107.42 in utilities, which is also rent, $100 in late fees, and then she would owe the court costs of this in this matter, correct?
Correct.
Have you reviewed the work orders that have been submitted by Ms. Battle since she has been a tenant?
Yes, I have.
Are you comfortable that they were all completed in a timely fashion?
Yes.
No further questions, Your Honor.
Thank you. Ms. Battle, do you have questions for Ms. Charles?
Yes, I do. So the first working order, are you able to disclose, or do you know firsthand what that was?
Your first work order was your shower water wasn't hot. You had some screws in your hinges that weren't secure. And when the water was turned on in the tub, it comes out of the shower as well.
Did you hear that? Her very first work order, she had some screws loose. It's interesting, right? Guys, I know I have some membership milestones to shout out. I'm going to wait till after this clip to do it. Just letting you know, I'm not ignoring you guys.
Okay. So how do you define complete? How is that work order complete?
Well, that was the work order you put in. The notes for repair are that the diverter for your hot water was repaired. Our construction company fixed the tub faucet that had came off, and we installed new screws in hinges on the door.
Right. So do you have anything that the actual construction company came, because nobody came? Because even if you go on to the next 3 orders, that's also listed as an issue because it was never addressed.
Well, the next work order
Is that
after that
correct?
was actually December 26th, and it says the door that was repaired, the screws were still not right, so we put new screws in it, so that wasn't a work order about the tub. The one after that was January 28th, and that was about hearing animals in the attic, and we installed new soffit and made sure nothing was in there. There was also one on January 27th. We adjusted your shower head and plunged your toilet and tightened a basket on your sink. There was one on February 14th that your tub was not draining and water was coming out of the faucet. We unclogged the tub and the shower head was working properly. And the last one was March 17th that your furnace was cutting on and off. And we took your furnace apart and checked all the fuses and put it back together, and it was up and operating properly.
Okay, so let's go into that more, because we might even have to subpoena the maintenance man, because this is going to become an issue. So when you say that you came into my bathroom and screwed the shower head, what would be your purpose of doing that? Because what was my request? My request was that it was still, the water was still coming out of both faucets at the same time, which have not been correct because you have not gotten a contractor out here. A contractor has not came out to my house about that. And let's go on to the heat, right?
Miss Battle.
I'm sorry.
You can't testify now. You can ask her questions. You will get a chance.
Okay, I'm gonna ask her a
was
question.
in
You're right.
the apartment between December 15th and 16th because
Wait
the
a second. Wait, everybody stop.
Wait.
There's no question
You
on
said I had to form it as a question. I apologize.
Okay, go ahead, Miss Battle.
Okay. So you're saying that a contractor came out, you said December 16th?
Correct.
And what contractor was that? The contractor that did the job?
Correct.
Okay. And when that contractor came out, what did they say that they did?
Repaired the tub faucet that had came off and repaired the tub diverter.
They repaired the what that came off?
The faucet for the tub.
One more time. Uh-huh.
And the diverter for the water.
Right. Okay. So let that address that the faucet pushing out and the diverter, that doesn't address the issue of the plumbing, which really, when I had somebody come out, they said the wall has to be taken down because what happened is they messed up behind it. So again, let's rephrase. Let's go on to the new one. Let's go on to the furnace. So when they came out for the furnace, and they came out to fix it.
Judge Washington doesn't have a courtroom right now. Her courthouse is being renovated. It's supposed to take up most of this year. I feel like that's what she said. So when she does in-person hearings, she actually borrows Judge Simpson's courtroom. So everything she does is on Zoom, or she has to go over to Judge Simpson's courtroom. So she doesn't do a lot in person right now. But, to answer that question. And the kids thing, the kids thing's annoying. It's beyond annoying. She's not on camera. The kids are running around. And like I said, it gradually gets worse throughout the hearing.
First time. What were their results from that?
I only have one work order for your furnace. They took it apart, checked the fuse, put it back together, and it was up and running. They cleaned it and put it back together.
Okay.
The furnace is new.
So no, it was 2 work orders. One was done in the middle of the night. I'm in the morning before they came into work.
Your Honor.
So I just wanted to be clear. So you don't have that work order for the morning? I'm asking the question.
1 second, there's an objection.
Your Honor,
you said it was an objection?
Can you listen to it, Ms. Battle?
I can hear him now. You say he had an objection?
Your Honor, I want to object. We're getting into the weeds here. I mean, you don't have a right to withhold rent or rescind a lease because of something small such as a tub faucet. And so, you know, we're getting into whether somebody actually came out and fixed it or when it got fixed. And it just seems to me that this is irrelevant to the proceeding that's going on today.
Well, it's object because it's not irrelevant to the proceeding because it's part of the reason on why I brought up the breach. Because at the end of the day, I kept trying to get somebody to come out to fix these things that are not fixed. Heat is a major thing. It's been cold. I still have a heater in my house because they haven't came back and got it and fixed it like they said they were going to. You get what I'm saying? It's still unconscionable things in the lease regardless. So everything about what I am arguing here is valid because I do have the right to rescind the contract based on breaches of the contract, just like you can come here on a quote unquote breach of the contract. It's the same thing. Why do I not get the same right and to hear what's going on so she can hear what's going on?
Your Honor, we will be more than happy to, the purpose of rescission, as the court knows, is to put the parties back in the same position they were before the contract got entered into. We will be more than happy to rescind this contract and basically have Miss Battle pay what she owes through the date of move out and terminate it so she doesn't have any more rent owing after move out. The problem is what she said to Judge Vandenberg last week, and I believe what she believes, is that when something gets rescinded, she is allowed to live there until she finds a new place. And that is not the law. We are more than happy to rescind this, to do away with this contract, let her pay her balance through the date of move out and terminate this contract so that she can move on and we can move on. But what we can't let her do is to live there forever without paying rent.
Well, let it show that by law, by contract law, if the breach is on your end, if you want to comply to it, like I said, because I did rescind it, and the breach was on your end, and it's rebutted on your end. And by law, under the landlord and tenant, it is called constructive possession. When you are in breach of a contract, and I'm not at fault.
All right. When someone uses a term that thinks it's a legal term, such as constructive possession, and you see Judge Washington immediately facepalm, the look on the lawyer's face, even Don is like, what? This isn't going to go well. It's not.
I am allowed under equity and law to stay in a place. It's called constructive possession. Constructive possession. The breach is not on my end. It was on your end.
Miss Battle, that's not the law, ma'am. That is not the law. Absolutely not at all. And ma'am.
Okay, so then if that's the case, if he wants to call out the breach of contract, then he's making it an uneven deal. Okay? So if he wants to say that he wants to accept the breach, then he has to accept the damages that come behind it. Because there's damages if I have to relocate on something that's not based on me. That's unfair. And that is that's unfair in bad faith.
Your Honor, I'm not trying to be unfair. All I'm trying to say
the breach is not on me. The breach isn't on me. So if the breach is on me, I will understand what you're saying completely. The breach is not on me, so I should not be held liable for y'all breach.
Yeah, but you're the one that wants to, Your Honor, but she is the one that wants to rescind. So it seems to me that she can't have.
I want to rescind based on the unconscionable contract. And what does my rescission also say? If it says it, if that's the case, if you all want me to leave and you don't want me to have the constructive possession, then you all should be paying for my relocation because it was your injury to me.
Can I say something without being interrupted, please?
I want you both to stop talking for a minute, please.
Go ahead. I'm sorry.
So, first of all, if you want to talk about whether a contract can be rescinded, that is not typically what happens in a landlord-tenant. That's in a standard contract situation. However, if there is, in fact, a situation where capital is for you to get some of your monies back, that's not something where you get to just rescind the contract. That's why all of this is the wrong procedure. However, Mr.
I'm sorry.
Please. Mr.
You
Fantair?
were saying something about getting your money. I need you to go back a little bit. It's breaking up really, really bad
So you're
because I
entitled,
can't hear you clearly.
if in fact the court were to find that, for instance, the property was not habitable, like there were enough repairs that were done so that the property was habitable. We're not gonna be able to make this out because of the children in the back. My recorder is saying she can't make it out.
I'm trying to make it out too, and it's just like breaking up a little bit. That's why I tried to tell y'all that this was not like a good time for me at all. Remember, you had got his time, and when I went to go say my time, you cut my mic off, and I was literally trying to tell you that I cannot. It's 3 o'clock is just not a good time. I'm getting my kids out of school. I don't have help when it comes to getting my kids out of school. So, yeah, but we can continue to try. We can just try to go for a morning time. I can do morning time.
Tim, I have on the morning. You don't have to figure this out. And if you don't figure it out, then the repercussions will be against you. You're gonna have to figure it out.
Well, hold on. I am trying to figure it out. I wouldn't be here if I wasn't trying to figure it out, or if I wasn't trying to,
I grant you that. I agree.
Oh man, I had to pause it. The kids. I have kids, and I this is getting to me. Legal fiction. You're lots of you problems. All right. Hopefully, I gave you guys enough pause to let your brains kind of reset a little bit. Here we go.
Water, I agree with that. But I have criminal dockets every morning. We don't have a morning docket.
You said what about a warning? Hey, stop. Hey. You said what about a warning?
I said we have criminal dockets in the morning, ma'am. That's what I said.
Yeah, I can do it in the morning.
That's not what I said.
Oh.
Hold on.
Judge Washington had to take a little break. He's like, hold on a second. Hold on. Yeah, this is a landlord-tenant case. They're on a timeline. The landlord wants her out. She hasn't paid rent. So that's why they're trying to get through this. But, yeah, if the court reporter
can't be that loud.
The court reporter can't take down with
No. Yeah, for real.
We're going to have a lot of upset people. But this is what I mean. I can't even talk over the kids. I feel like Judge Washington now. This is why I say this is frustrating. And I warned everyone at the start, you're going to be frustrated by the end, and this is why. The kids, man. Wait, did I play it?
Mr. Fantera, this is not working. It can't be recorded properly because of the background noise. I can't finish this today. Are you available on the 16th at 9 in the morning?
I am. Make sure my witnesses are Dawn.
Yep.
Ms. Battle, are you available at 9 in the morning on February 16th?
May 16th, Your Honor.
May 16th. I'm sorry, I'm discombobulated.
Yes, 9
a.m. works?
Yes, 9 a.m. is perfect.
16th at 9. We'll be back here again.
Your Honor, can we require, since I asked before and you said you didn't give notice, her to be by video Zoom?
Yes, Ms. Battle, can you come via video Zoom, please? Ms. Battle, you're muted.
I'm sorry. I keep trying to mute it because I think that's why I keep muting me because of my background. But I said, yes, that's fine.
Okay, thank you. I appreciate it.
And I will also mail copies of all of the exhibits that I submitted to the court to Ms. Battle so that she has them beforehand.
Thank you. We'll see y'all.
I appreciate it, David.
See y'all May 16th at 9 p.m.
Okay, thank you.
Oh, that might be the best comment of the night. Thank you for that. Oh, well, the good news is we get a round 4. We're gonna get to see this sovcit again. The bad news is you may be entitled to compensation by listening to that. That's hilarious. Oh, thank you. Oops. Didn't mean to hit play. Apologize for that. That's the next clip. I want to call out the membership milestones. Pear, thank you so much for the 8 months. That is awesome. Thank you, Pear. Carla for 5 months. Carla, thank you so much. Rich for 15 months. That is awesome. Thank you, Rich. Terry for 8. Thank you, Terry. Girl named Joe, member for 3 months. Thank you, girl named Joe. Crazy Rider with the $2 super sticker. Thank you so much for the super sticker, Crazy Rider. I appreciate it. Phil, what's up, buddy? How are you? Aspirin fun for the headache. Absolutely. Judge Washington needs it more than everyone else, though. Hopefully she's recovered by now. All right. Going into the next sovereign citizen. This is the state of Washington. Again, I don't know the judge's name, and I cannot read her little name tag thing. Okay, let's just go.
Mr. Warren, you want to come on up and, all right. You want to have a seat up here? Or would you rather stay where you are?
I'll stay here. Then.
Okay, that's fine. We can still hear you and communicate well. So we're taking up the case 24-130, and Mr. Warren, you've filed this motion to dismiss the state's charge, and I've had a chance to. We were together, I don't know, a few weeks ago, and we set this hearing. And so I'm going to turn to the state here.
Judge is a completely different judge, unless it's the same name. I think you're trolling me, though. It might be, maybe it is Babcock, but anyways, there is a Judge Babcock in Michigan. That's who I'm thinking of. Yeah.
I don't have anything filed.
That's correct, Your Honor. And when I was reviewing this late last week, it came to my attention that nowhere in the record did the court authorize the defendant to proceed pro se. And the issue the state has is we haven't provided discovery to the defendant. We haven't provided discovery to counsel for the defendant. And until he's authorized by the court to go pro se, we can't really respond to his motion either.
Well, I think you do. We're at a motion, and this was filed in February. And since April of 2024, it's been clear, Mr. Warren, who's also to us known as Mr. Azeltine, but Mr. Warren is proceeding representing himself. And he's made it very clear in his pleadings, and I'll allow that. And it's been allowed throughout. So are you going to respond to this motion today?
I can respond orally to the motion, Your Honor. Yes.
Okay.
I do have to express some hesitation and concern here, Your Honor. The state currently has a case coming back from a Superior Court appeal where the court did not go through the pro se properly with the defendant, and therefore the court is overturning that case.
Well, this goes back to filing of April 2024. I haven't looked through all of the recordings, but I think Mr. Warren, I think it's been clear that you're wanting to represent yourself since this beginning. Is that right?
Yeah, let me make that clear. Without recourse, as my unrebutted affidavit on file in this case stipulate, I am not the ens leeches, Mr. Azeltine. I'm not Mr. Warren. I'm a man. My mother called me Ty Warren, and I'm of the Azeltine family, sovereign as spoken of in Yickwold versus Hopkins, and not the corporate artificial entity Ty Warren Azeltine in all capital letters, nor representing the defendant, Ty Warren Azeltine. I'm not here pro se. I'm here by special visitation, sui juris, in propria persona. You may call me Ty Warren.
Okay.
I'm here under duress and threat of arrest by special visitation, reserving all rights without prejudice under UCC 1-308, and refusing any contract not explicitly agreed to. For the record, I do not consent to the court's general jurisdiction over my person.
All right. So you're in a criminal court and you have the right to be represented by an attorney or to represent yourself, to speak for yourself, put it that way, and not have an attorney represent you. So where are you?
I'm here to present myself as a man,
Okay.
not as a court defendant.
All right. And I think throughout, well, I know throughout, we've talked about this whole idea about appointing counsel or not, and we haven't done that because you didn't want that. And I remember the times that we've been together. I can't speak for any other judges without looking at their records or listening to their records. So, and the prosecutor's office has been here throughout the times that you've been before the court. And the last hearing, April 8th, was when we cleared up that warrant and we set this hearing. So it's abundantly clear, and that Ty Warren here is speaking for himself or representing himself, and we're going to go forward on that because we've had those discussions for over a year now.
Again, I'm not representing myself or the defendant.
Right, I understand. So I see in the pleadings that you filed that there's at least one. First thing that might be most dispositive is the motion to dismiss based on Court Rule 3.6, which is a suppression of evidence, saying that there was no basis in the law for you to be stopped by the officer. So we're going to start there. Well, I'll make the record here as to jurisdiction and venue. I think I've made that record already, and I don't see anything. I'll hear from the state if there's anything else, and we talked about this at the last hearing, that this is the district court. This is an allegation of a driving offense under RCW 61, also an allegation of obstructing law enforcement. Those are properly filed in this court as they're alleged to have occurred here.
All right, this is a good place to pause. Michelle, thank you so much for the super chat. I appreciate it. Happy Nurses Week to all my fellow nurses. I did not know it was Nurses Week. Happy Nurses Week to you too, Michelle, and to all the other nurses out there. And thank you so much for the super chat. Legal Fiction, thank you so much. I appreciate it. Katie Zed's Milk Bone Fund. Thank you. Yeah. Katie, if you're still here, I'm going to go throw a milk. I don't have a milk bone. I'll find something. I'll just launch it as far as I can south. Hopefully it gets down to you. It's going to, but we'll try. We'll try. Thank you, Legal Fiction.
In Thurston County, and this court has jurisdiction, subject matter, and in personam jurisdiction. So venue is proper as well. So
I'm here to challenge that.
I understand, and that's part of your motions. Just making the record that there isn't any basis in your motions that have undercut that reality. So the court does have jurisdiction and venue is proper. So we're gonna hit that 3-6 motion. And I'm gonna hear from the state as to what evidence they have to present. And I'm looking back to that motion. I think it's about 33 pages. It was filed back in February and reiterated throughout. So Mr. Thompson.
You're speaking of my affidavit.
Yes. And
every judge in this court in Thurston County is extremely nice. I like it. I enjoy that. But there's sometimes a time and a place to not be so nice. And they don't really switch off the niceness too well. Even when they're angry, they still come off being really nice. Maybe it's just a Thurston County thing. I don't know.
I mean, you've filed a lot of information. I've taken it all together. It starts out with that motion to dismiss from going back to, oh goodness, June of 2024. I misspoke.
You can sum it all up with my most recent affidavit.
Yeah, and that including in my reading, everything you filed. So now I'm going to jump to the state because they're the ones who have to defend against your motion. I will hear more from you. So, Mr. Thompson?
Thank you, Your Honor. And the sworn statement that our office provided at the initial hearing stands that the defendant was stopped for speeding, and during the course, well, that was the basis of the stop was speeding.
And so resting on that initial probable cause finding in April.
That was, yes, correct. That was the basis for the initial stop, which would give rise to the Terry stop for an infraction. And from that point on, the defendant refused to give name and gave a world passport ID card or world passport. I don't even know how to fully describe it accurately, other than not a document from a government entity.
So anything you'd like to say more, Mr. Warren or Ty Warren?
Yeah, plenty to say.
As to
Nanya, thank you so much for the 5 good memberships. I appreciate it. Welcome to the 5 new members, and it's for putting up with the kids. You guys all put up with the kids. I took my headphones all away from my ears. I could still hear it, but yeah, I didn't want to listen to that again. So I appreciate every one of you putting up with the kids.
that issue, let's kind of focus in on issue by issue.
What the prosecutor has just said. He stated that I did not give a name, which, and then he counteracted himself by saying I did give world passport ID. And then he said it was not a valid or whatever he said. And not valid or not recognized by the state. But whatever the case, I would like to present my what I have to say here. I'm a man visiting here, especially not generally sui juris and solely challenge jurisdiction.
Let me ask you a quick question. Did you already file the information that you're reading?
No.
No, this is new?
Yes.
Okay. All right. You have an extra copy?
It's just my oral.
Yeah, he's one of the sovcit types that doesn't walk up to the podium or the table. He's sitting from the gallery talking, so he's probably 10 feet away from the mic. That is why we can't really hear him. But yeah, no, that does kind of suck. Also, real quick, isn't that special? Judge Boyd does still stream. She does almost daily. I kind of stopped watching her. There's a lot of channels that exclusively cover Judge Boyd. So when I would play a Judge Boyd clip, I wouldn't get a lot of views on it. So I've kind of, I mean, I don't want to say I've stopped watching her, but I don't cover her as much as I used to. So if that's why you're asking, she absolutely does still stream.
Okay. All right. Let's see. Try and focus in on the motion to dismiss that you have for suppression of the evidence.
This is what this is all about. It's all about.
Yeah, apparently I can't read. I apologize. Judge Bryant. That is not Judge Boyd. I was reading the chat and they're talking about Texas judges, so I just put the B as in Boyd. Bryant doesn't stream as much. I did just throw a video up with her. Let's see, today's Tuesday. It was probably last Thursday. I put a video out with it. No, I think it was over the weekend actually. She doesn't do it as much. Yeah, maybe one day a week it'll pop up, and it's usually a jury trial. And so I just, I don't know. But yeah, not nearly as much as she used to. All right, now that I can read again.
Jurisdiction.
Well, we're not talking jurisdiction.
Proven on the record, and I have seen no proof of jurisdiction.
Talk to me about your motion to suppress. Talk to me about your allegation.
I'm here to establish jurisdiction or not.
Well, I've already maybe I should be more clear.
There are no facts on the record.
I deny your motion as to jurisdiction in this court. So this court has jurisdiction and venue. What I need to hear from you is what do you have to say about your motion to dismiss for a bad stop?
I can't say anything about a motion to dismiss until jurisdiction has been established.
I've denied your motion. This is the correct court. We have jurisdiction, so move on. You can disagree with the court's order, but You can't make it better by just continuing to argue about it. So let's move on to that other motion that potentially is dispositive, the stop.
One moment, please.
Sure.
I respectfully object to that ruling and give notice. I contest the court's assertion of jurisdiction all the way. Let the record show that I timely and persistently challenge jurisdiction, and that challenge remains unanswered by factual evidence.
Anything else? Just looking back through your affidavit and your motion. Anything else for me to consider from you?
Like I said, I have plenty to consider.
Okay. About, first off, as to this motion dismissed based on the bad stop, is what you say.
Yeah. Excuse me?
Your motion to dismiss based on a lack of good reason for the stop. That's what I'm first dealing with.
I can't even address that issue
Okay.
without jurisdiction being established.
Okay. All right. Well, all right, Mr. Ty Warren, Mr. Azeltine, however you want to be referred to. So this is the deal. I'm granting your motion to suppress all evidence after a stop. I have no evidence presented that I can consider. This was filed by you in April of 2024. And there's been affidavits and information filed thereafter, all in the court file. We've set this for trial.
But Judge, you can't rule. You can't go any further. You can't rule in his favor. You haven't proven jurisdiction yet, so you can't dismiss this case. That's not how this works. Tell him, sovereign citizen, she can't dismiss it. I know. That I was shocked when I heard it too. So let's hear her out.
We've set this for motion as recently as April 8th. State was present. It's kind of like, for whatever reason, the state decided not to join or prosecute. So under Rule 3.6, I don't have any evidence to overcome what your assertion is that you were peacefully driving down the street. And simply the probable cause statement from the beginning to allow the set of release conditions is not sufficient. There isn't anything other in the court file, in the court record, that would allow the state to overcome your motion to dismiss or to motion to suppress evidence. So all evidence obtained, stop forward, is suppressed or not allowed to be brought forward in trial by the state against you. With that ruling, Mr. Thompson, from the state's point of view.
I believe the court is, well, I have nothing to add, Your Honor. The state will be filing an appeal.
All right, so are you saying that with that order of suppression, state, you're thinking an interlocutory appeal and able to go forward?
Yes, Your Honor.
Okay.
Well, I suspect the court intends to dismiss the case at this point. So I don't think an interlocutory appeal is what will happen, but an appeal nonetheless. You know, again, the state stands by its position that I put into the record regarding his appearance today pro se. I still do not believe that the court has gone through it properly. I will note one additional thing for the record, that in his motion to dismiss, he specifically says that he's doing so under duress, which calls into question the validity of any of his filings. And the reason why the state still believes, even over his objection, counsel should be appointed, because he is not here of his own free volition, as he said more than one occasion in more than one filing.
Clear to the court he is throughout all of this. The semantics that he likes to use are not persuasive to the court. So
Yeah, state, you got to do a better job, or the officer. Yeah, suppress the evidence after the stop. Does that mean but that's everything after the stop. what was he originally pulled over for? I don't remember. If it was speeding, the speeding charge would still stick, wouldn't it? It was just everything afterwards. So the ID, the false ID, whatever, is dismissed or whatever. I don't remember what exactly the charges were. Yeah, but it's crazy. Do a better job, state. You just lost to a sovereign citizen. You're gonna owe the whole group. Man, that's not a good look. Legal Fiction, thank you so much for the super chat. I appreciate it. You've been generous tonight. Thank you. I object and hereby give notice. All right, thank you. Okay. Well, there's only about a minute left of this, so I'm just gonna let the rest of this thing play out. You guys have been awesome tonight. I know I ran a little short tonight. My travels yesterday have caught up with me today. I was tired last night, but I was kind of wired from all the sugar I was drinking. And then today I've just been, trying to catch up on the lack of sleep I've gotten over the last 2 days. So shorter video tonight, but I do appreciate everybody coming by, all the super chats. You guys are awesome tonight. Thank you so much. Big In, once again, thank you for the raid and for all the raiders that came over and hung out with us. Thank you so much. If you haven't done it already, please hit that like button. And I'm going to go find us someone to raid. It's probably going to be Lone Wolf. I'm just going to say it's Lone Wolf. That's where we're going. So go over and tell Lone Wolf I said hello, and I will see you guys tomorrow. Until next time, bye.
But as I said, the prosecution's decided, not to present. So, as we know, Mr. Azeltine, as we know you as, this matter is dismissed, given that suppression of all the evidence, and you're free to be on your way.
Thank you.
Thank you, sir. Mr. Stashevsky, you got some clients ready?